Moving on, the second rule of conduct for practitioners is diligence. This rule of conduct is pretty easy to understand. It simply states that diligence must be exercised in preparing and in assisting in preparing, approving, and filing either returns, documents, and other papers relating to IRS matters. So the IRS will presume diligence on the part of a practitioner if the practitioner relies upon the work product of another person and uses reasonable care in engaging, supervising, training, and evaluating the person. So diligence also requires that a practitioner not unreasonably delay the prompt disposition of any matter before the IRS. So, in other words, is as soon as a matter is brought before the IRS and a practitioner is representing a taxpayer in that matter, they may not act unreasonably to delay the fastest adjudication or conclusion of that matter. The third rule of conduct is pertaining to information or records. So, information or records properly and lawfully requested by either an officer or employee of the IRS must be promptly submitted. So, as soon as possible, essentially. The prompt submittal, however, does not matter as much if there is a reasonable basis for a good belief that the information is privileged, meaning that it's protected under an existing CPA to client relationship, or the request itself is not proper and lawful. In that case, the practitioner has an excuse and can therefore either delay submittal or act in another way in regard to the submittal. So, a practitioner is also required to provide information about the identity of persons that he or she reasonably believes may have possession or control of the requested information if the practitioner does not have that information. The fourth rule of conduct is knowledge of a client's noncompliance. So, if a practitioner knows about a client's noncompliance of a tax regulation or law, and these it can be if the practitioner finds out about a client having not paid a tax, or maybe it's an error in disclosure on a tax return. Then the ethical rule of conduct that the IRS imposes on a practitioner is a prompt advisal of the client of that noncompliance, and also a prompt explanation and education to the client about the consequences of the noncompliance, error, or omission. So, similarly to the conflict of interest rule of conduct, Circular 230 doesn't require the practitioner to notify the IRS. As I said before, this is an ethical rule. So, the remaining rules of conduct, I won't go into too much detail about them. You can review these on your own time. But they include no negotiation of income tax refund check issued to client. So essentially, this just means that a practitioner cannot negotiate with their client in the situation where the practitioner has or the taxpayer has an income tax refund check, and perhaps the practitioner has it on hand, or the income tax refund amount, the practitioner may not negotiate with the client about receiving any part of that tax refund check. Unconscionable fees simply means unreasonable or unfair fees that may be imposed on a client. Contingent fees, although in existence in client to attorney relationships may not be charged in a practitioner to client relationship, particularly in these four instances. So these would be the IRS examination, the amended return, the claim for refund or credit, or an actual judicial hearing or proceeding. Then the eighth rule of conduct is a practitioner must return client records if the client requests them, regardless of any fee dispute that exists at that time. The ninth and final rule of conduct is regarding advertising and solicitation. So Circular 230 allows practitioners to advertise and solicit as long as the statements or claims that they make are subject to factual verification and are not a product of false, fraudulent, misleading, deceptive, or unfair motives. So what are the sanctions if practitioners violate these 9 rules of conduct? Well, the practitioners may be censured, which is a public reprimand. They can be suspended or disbarred from practice before the IRS. And this can happen especially if the actions of the practitioner were willful violations of all of these rules of conduct that I mentioned. So the Secretary of the Treasury, who, and as you remember from class 1, the Treasury Department is the higher organizational entity on top of the IRS. So and the Secretary is the top official in the Treasury Department. They may also censure, suspend, or disbar from practice before the IRS any practitioner who is shown to be incompetent or disreputable, refuses to comply with the rules and regulations, or willfully and knowingly with intent to defraud, deceives, misleads, or threatens any client. So some examples would be if there was a conviction of an offense that involved dishonesty or a breach of trust, so these would be like fraud or embezzlement, providing false or misleading information. If the practitioner is a CPA and they're suspended from practice, or if the practitioner is willfully evading or assisting others to evade paying federal taxes. Moving on is our second section. So this section we will go over tax return preparers. So these are people that may be practitioners but are called tax return preparers if they are preparing another person's taxes. So the way that the IRS defines a tax return preparer is any person who prepares a tax return for compensation, or any person who employs one or more persons to prepare for compensation all or a substantial portion of any return of tax or claim for refund under the IRC. So you see that there's two situations. So the first one is easy. It's a person who prepares a tax return for another person and they're getting paid for it. The second is if they are a person or a company that employs people, pays those people, and those people that prepare the tax return are doing all or a substantial portion of the tax return or claim for refund. So how is this defined in this second definition for a tax return preparer? Well, a portion of any return or claim is deemed substantial in general unless a condition for unsubstantiality is satisfied. So what is unsubstantiality? Well, an unsubstantial portion is either a portion that's less than $10,000 or less than $400,000 and less than 20% of the gross income on the return or claim. If there in the return there's more than one schedule entry or other portions, then all of them will be combined to determine whether or not a substantial portion of the return or claim is being prepared. So persons who fall into these two definitions may be a person who provides to a taxpayer or other preparer sufficient information and advice so that completion of the return is simply a mechanical matter. So a CPA would fall under this definition. So a non-signing tax return preparer who prepares all or a substantial portion of a return or a claim for refund. So this could necessarily be one of those EAs that I said, or an attorney. So tax return preparers are held to due diligence standards much like practitioners are. So significant aspects of the return preparation require that the tax return preparer not only make factual inquiries to ensure the accuracy and truthfulness of the tax return, but they also take a position relative to tax law. So what that means is the tax return preparer must assess the scenario and appropriately apply the tax law to the facts. So taking a position then means if they're filling out like different sections of the return, they need to know how the facts of their client apply to what the law requires. So a tax return preparer can rely on information provided to them without actually having to verify that information through a third party if they acted in good faith. Good faith requires that the preparer make reasonable inquiries if they see on the face of it that the information appears to be inaccurate or incomplete. And the preparer can't ignore the implications of that information. And they have to make appropriate inquiries to their client if there's documentation there that might actually conflict or water down the different tax avenues and instrumental deduction strategies. So essentially, they just have to employ due diligence. And separate from the other conflicts, not conflicts, but rules of conduct, the tax return preparer, if they see that there was an error or omission that was already filed with the IRS, then the tax return preparer must notify not only the taxpayer of the error or omission immediately, but also advise them about the consequences of the error or omission. So a tax return preparer who discloses or uses any tax return information without the consent of the taxpayer will be imposed a penalty. So some exceptions do apply, which I don't cover, but in order to reveal or disclose taxpayer information that a tax return preparer has on hand based upon a financial relationship with a taxpayer, then the tax return preparer must get the consent, and the consent must be written and formal and authorizes the disclosure for a specific purpose. And these three elements below in this second bullet point are what needs to be written in this formal consent. So confidentiality also applies, especially if the tax return preparer is also a federally authorized practitioner. So like some of this information I already went over, but tax advice given by these individuals must follow within the scope of the individual's authority to practice before the IRS. And so this element is just referring to the chart that I showed you prior. And lastly, the penalties for tax return preparers for violating the rules for tax return preparers are listed here. And a lot of this is repeated information, and there's pretty much just the same.